Breaking news, the Justice Department issuing more than 30 subpoenas in recent days to people in Donald Trump's orbit as part of its January 6th probe. It's a major development in the investigation amid the midterm elections, which of course are now only 2 months away. And sources tell CNN that those who were served those subpoenas are among Trump's top advisors and allies. That includes Brian Jack, Trump's former White House political director, and his former deputy chief of staff, Dan Scavino, as well as his campaign manager, Bill Stepien. Evan Perez is out front. And Evan, finding out about more than 30 subpoenas in just a few days, that's a lot. What do you know about them?
Well, that's right, Aaron. I think what this signifies is really an intensification of the Justice Department investigation. All of these subpoenas coming in just in the past week or so. It appears to be an effort by prosecutors to get ahead of the quiet period. This is a 60-day period during which the Justice Department generally tries to do any overt steps that could be interpreted as trying to influence the midterm elections. So that appears to be the genesis of some of the activity. The scope of these subpoenas, we've seen at least a couple of them, appear to have a range of issues that they're going after, including some of the fundraising for the former president's Save America PAC, some of the efforts behind the fake elector scheme, as well as some of the efforts that they were making to try to find fraud and whether there was any indication that they had proof of any of that fraud. Again, this is something that prosecutors seem to be trying to connect the dots behind some of the efforts to overturn the election results. So you mentioned some of the names. Bill Stepien, who was a former campaign manager for the former president. Sean Dolman, he was the CFO of the 2020 campaign, and of course Dan Scavino, who was the deputy chief of staff. He was of course the guy who was writing a lot of the former president's tweets. So a lot of very important figures very close to the former president getting these subpoenas.
And this is in the context of the probe into the classified documents found at Mar-a-Lago, Evan. So today, Trump's legal team opposed both the DOJ's bid to resume its review of classified documents and its picks for a special master. That's what we had heard today as this day has gone on. Why are they objecting?
They say they're not really going to explain why they're objecting, Aaron, in this court filing. They just say that they have objections to them and they want the judge essentially to force them to explain it. I'll read you just a part of what they said. Plaintiff objects to the proposed nominees of the Department of Justice. Plaintiff believes that there are specific reasons why those nominees are not preferred for service as special master in this case. Plaintiff also submits that it is more respectful to the candidates from either party to withhold the basis for opposition from a public and likely would be widely circulated pleading. So essentially they're asking the judge for permission to explain to her behind the scenes why they don't want these two specific former judges that the Justice Department had recommended.
All right, Evan, thank you very much. Reporting from Washington, I want to go now to David Laufman, the former chief of the Justice Department's counterintelligence section and who investigated Hillary Clinton's handling of classified documents. So, David, you know about this from every angle. Let's start with the subpoenas. The Justice Department, we found out, issues more than 30 subpoenas within a matter of days for its probe into January 6th. What do you make of the fact that there are more than 30 subpoenas happening in a matter of days at this specific time?
I mean, Aaron, it tells me that the Justice Department and the FBI are all in pursuing what prosecutors and agents refer to as logical investigative steps. They're building on what they've learned from other witnesses, from other documents, from other subpoenas, from other search warrants. This is the way classic investigations are conducted, moving up the chain, so to speak. They're now encompassing individuals closer and closer to the president to learn more and more about what the president knew and when he knew it, with respect potentially to efforts to engage in wire fraud, defrauding the, donating public, if you will, with respect to the campaign organization, or efforts to defraud the United States with respect to fomenting a false slate of electors to suborn a free and fair election.
So the context, as we said, is that the Trump legal team today opposed the DOJ's bid to resume its review of classified documents found at Mar-a-Lago, right? The DOJ has said, look, whatever you want to say about executive privilege, it wouldn't apply to classified documents. They want to go ahead, therefore, with their review because they say time is of the essence, that it's urgent for national security reasons. The Trump team argument as to why they should not do that, they say in part, in what at its core is a document storage dispute that has spiraled out of control, the government wrongfully seeks to criminalize the possession by the 45th president of his own presidential and personal records. Now, David, I do want to be clear that this is not a document storage dispute. They had months to turn over documents that were requested. The Trump lawyer even signed a letter that all the requested documents had been returned when they had not been returned. So it's not a document storage dispute. But do you have any fear that the judge will buy this?
Yes, I have fear that the judge will buy it. It's my hope that the judge will take the off-ramp that the Justice Department has offered her. The Justice Department could have taken a sledgehammer to this judge's prior ruling and obliterated all the grounds she cited for imposing the restrictions she did on the government's investigation. Instead, the Justice Department shrewdly took a scalpel to that order and focused on that narrow subset of materials, 100 classified documents, classified as high as top secret code word, and asked the judge for a stay of that portion of the order. The position the former president is taking is completely untethered to law or custom and practice. He has no right or possessory interest to classified documents, nor should a private citizen who's now a special master be interfering in an ongoing criminal investigation, and one that has national security implications.
And there's also in the footnote, Trump's legal team says, of course, classified or declassified, the documents remain either presidential records or personal records under the PRA. They keep making this argument. I haven't found any legal expert that would say that a classified document is part of the presidential records. Is there any way they could make such an argument?
No, first of all, they failed to cite a provision of the Presidential Records Act that says that presidential records are the sole possessory interest of the executive branch, which did not include President Trump after he left office. And secondly, classified government documents are governed by executive order, by long-established Supreme Court precedent that vests in the executive branch the sole discretion for determining what is classified and how those documents should be handled. So, they're trying to shift and deflect focus from what is, at its root, very problematic behavior that exposes this president to criminal jeopardy.
David Leffman, I really appreciate your time. Of course, the significant headline, more than 30 subpoenas handed out in just the past few days by the Justice Department in the January 6th probe.